Hello, everybody. Welcome to our HRW Roundtable on the OSHA COVID-19 vaccination and emergency temporary standard. Vaccination or testing, which, as we all know, requires employers to ensure is the word used, that their workers, either that they're vaccinated or that they're tested weekly and wear a face covering at work. Now, all of you may be thinking, why are we here, Cathy? Because didn't I just hear on the news that one of the circuit courts put a whole kibosh on this thing and it's all been temporarily halted and we don't have to worry about it? Well, the fact that we're still here gives you a clue as to what we think on that subject, but I'm going to give sort of a brief introduction about what are the various provisions of this law, just to get everybody on the same page. But then Scott Roberts, who, by the way, just won a case on behalf of a college who was sued by 10 students who were denied a religious exemption to the vaccine. Scott is going to give us the scoop on what is really going on with the courts, where do things stand, maybe a little crystal ball gazing on as to where things go. And maybe if we're lucky, he'll give us a few juicy tidbits about that religious discrimination case, because it was a fascinating one. So after we hear from Scott and get confirmation that, yes, there is a stay, but it's just a stay. The whole law has not gone away. It's still there. OSHA still has authority to enforce workplace safety. After we hear from Scott, Dave Wilson, and Dave Wilson, many of you know, uses the expression gatekeepers of fairness to describe human resources. And that is his approach to presenting. It's all about how do we get this done simply, fairly, straightforward, employee-friendly manner. So Dave and I are going to go through the nuts and bolts of this thing, what you need to know to implement it. Then, after, we're going to talk through the ETS, but the one thing the ETS doesn't tell us is, well, what about this pesky problem of religious and medical accommodations? The emergency temporary standard just says, see the EEOC guidance and make sure you grant accommodations. Well, who better than my thoughtful, careful, user-friendly, accessible colleague, Janette, to explain all of this in a way that's straightforward and cuts through all the nuances and makes it doable. Then after we hear from Janette on accommodations, we're going to hear from my partner, Pete Moser. And Pete, as you all know, he's not just an employment lawyer, he's a labor lawyer. He understands about unions and collective bargaining. And for those of you in the audience that have a union, you may be asking, well, do we have to get the union's permission to do all this stuff? And what if the union says no? Or what if the union wants to do even more and make us do stuff that this standard doesn't make us do? What do we do? Pete's going to give us some information about that. And then in our remaining time, it's going to be questions and answers from all of you. So what you need to do is, if you have questions, you go at the bottom of your screen, you'll see a little box that says Q&A. Use that for your questions, because any questions that we don't get to during the seminar, we are going to send around those questions and answers afterwards. So please do put the questions that you have there. You also have access to a chat button, and you can use the chat. You can chat with each other. You can chat with us. If we're speaking, we may not respond right away, but that's not the place for questions. You can put questions in there, but that's just questions for us. If for questions you want answered during this webinar and afterwards, use the Q&A. All right, let's go to the next slide. Just, you know, if this webinar is not legal advice, and all the more reason we say that is this seems to be a bit of a moving target. We can tell you what this ETS says, but we got to follow the news. We got to follow the courts. Some of you are in industries that are subject to other regulations. Some of you have operations in other states that have their own requirements. So make sure that you learn from this seminar, but don't rely on it as legal advice. If you have questions, reach out to us or other counsel. And also, you already know this, but this is being recorded. None of you who are watching are being recorded, but your Q&A will be public. I think there might be a way to submit questions anonymously so that we have this, and we'll be also posting a link for those of you who thought that I was talking too fast, which I am wont to do. All right, Next slide, let's get going. So what's the bare bones of this thing? This applies to employers with 100 or more employees, okay? 100 or more, and it's about safety. OSHA isn't an organization that its mission, its goal is to protect workers on the job. And OSHA, when you read this ETS, the actual ETS is not very long, but there's hundreds of pages of statistics and documentation where OSHA says, if we implement this, we are going to save thousands and thousands of lives. And we, OSHA, and you employers have a duty to provide a safe workplace. And we believe this is a straightforward, clear, doable way for larger employers to make the workplace a whole lot safer. That's what's behind this. So next slide. All right, so what do you have to do? You're going to have to get the vaccination status of all of your employees, and you got to get and keep proof. You got to find out for each and every worker, are they vaccinated? And then you have to implement a policy. Either it's a policy that says you must be vaccinated as a condition of employment, or a policy that says you have a choice. You can either get the jab, as the British say, or you can get tested for COVID-19 weekly and submit those results to us, and at the same time also wear a face covering at work. So that's the policy choice. Next slide. The other requirements are you're going to have to give people paid time off to get the shot and recover from it. You're going to have to give your employees all kinds of information, but OSHA makes it easy because most of it's in fact sheets that you can just download and print. But if you're going to have to develop your own policies, but OSHA gives you a template policy. You're going to have to require in that policy that your employees will tell you immediately if they've tested positive, and then you must remove them from the workplace and not bring them back until you go through certain safety hurdles. You got to report any COVID-related fatalities or hospitalizations that are due to COVID and due from the work site to OSHA, and you're going to have to keep a lot of records which must be made available on short notice. That's the bare bones of this thing. So let's go to the next slide. When's this all due? Well, pretty much most of it is due by December 5th. You know, getting everyone's vaccination status, implementing a policy, making people report the positive tests. But the requirement that you ensure that people are tested, that's not till January. But everything else is in December. You don't have to ensure that everybody's tested, but all the other parts are due very soon. This standard is likely to be in effect for 6 months, but it could very well be extended. And while there's a public comment period, people can comment on the ETS. It's in final form. It's just that they may make further changes after they get public comments. And like with any OSHA standard, if you violate it, these are the penalties, over $13,000 per violation. And then that's, you know, $136,000 if it's willful or repeated. But here's the part where I want to bring in Scott, because wait a minute, there's all these pending legal challenges. So what is that? Where does this thing stand, Scott? And what does it mean for us? Let's go to the next slide. Crystal ball gazing by Scott. Let's go one more.
Scott, you're on mute. Even before, and thank you both for letting me know I'm on mute. I think that probably happens most times I get on Zoom, and I think most people find it the preferred way for me to be on Zoom. Even before the ETS was implemented, promulgated and implemented, there were a large number of lawsuits against private institutions that had instituted or implemented vaccine mandates. And lawsuits against those organizations and institutions have become increasingly common. Since probably June of last year, May of last year, a number of colleges, universities, healthcare organizations have implemented vaccine mandates. And there's been a plethora of lawsuits challenging their authority to institute mandates, particularly if they were public institution, or challenging any refusals to grant exemptions from mandates on medical or religious grounds. I don't want to get into that issue of exemptions yet. Janette, as Cathy had mentioned, we'll talk about that later. I don't want to talk about the ins and outs of evaluating such requests. But based on my experience so far in defending institutions in these litigations, I can observe the following. And that is that many of the requests for exemptions from vaccine mandates that are claimed to be religious are in fact grounded in politics and philosophical objections. And to give you an idea on how to, a way to highlight that, one institution I represented in the prior year had received but 9 requests for exemptions from those vaccines that are mandated for students attending schools. 9 out of a student body of 4,000. With respect to the COVID vaccine, however, the same school received 176 exemption requests, a multiple factor of what it had seen before. And many of the religious exemption requests included very charged language that was politically driven, that could be found on any number of websites that coach people on how to get these vaccine exceptions and the like. So this heated opposition to vaccine mandates has been out there. And so it's no surprise that when OSHA issued the ETS, it was met with a flood of lawsuits. The ink was barely dry on the ETS when it seemed that everybody started suing. Right now, there are about 30 cases pending in 10 federal circuit courts, including some suits that say that the ETS doesn't go far enough. So, as I said, the ink was barely dry when this came out on November 5th, when the the Fifth Circuit Court of Appeals issued a stay, basically telling OSHA, you can't go anywhere right now with this law, with this regulation. Now, it's important to note that the judges who issued this stay, the Fifth Circuit is the area that covers Louisiana, Texas, and Mississippi, all deeply, deeply red states. And the panel that issued this decision is a heavily Republican panel, a Reagan appointee and 2 Trump appointees. And they, in their stay opinion, took a very, very dim view of the ETS, going so far as to suggest that its entire conception was in bad faith. And they focused on the economic costs of ETS while curiously underplaying its benefits and the toll of the pandemic. So as it stands right now, OSHA's ability to enforce the ETS is stayed. That means just simply it's delayed. It has not, as some folks on some commentators on some news stations have asserted, been declared illegal. It is still out there. So what's going to happen next? Today is a critical event in what's going to happen next. As I said, these lawsuits are now pending in multiple federal circuits, over 30. And what you don't want to have when that happens is having multiple courts reaching multiple decisions with multiple different results. So the federal courts are going to hold a lottery today. This is not the good kind of lottery with cash prizes and money. This is a lottery in which the winner gets a boatload of lawsuits. And that's what the winning court will get. And so quite literally today, the clerk for the multi-district courts is going to take a drum, throw in numbers, roll them just like you would see on TV, reach in and pull out the winning district. And that lottery, as I said, is scheduled for today. And that lottery will determine the circuit court that's going to oversee a consolidation of all of these matters. And that court is going to have complete discretion over to whether maintain the stay that is currently in effect, get rid of the stay, or do something else. So it is not an overstatement to say that this administration's COVID-19 strategy is very much based on today's luck of the draw. If you end up with a very, very aggressive red state conservative panel, it may not go very well. If it ends up in a different district where they're more receptive to the arguments that OSHA is making as to why this ETS was put in place, then it could go well. So where do we stand now? This is where OSHA stands, and this is what it posted on its website just yesterday. It states on November 12th, the U.S. Court of Appeals for the Fifth Circuit granted a motion to stay OSHA's COVID-19 ETS. And the court ordered that OSHA take no steps to implement or enforce the ETS until further court order. And that further court order may come from another court. It then added, while OSHA remains confident in its authority to protect workers in emergencies, OSHA has suspended activities related to the implementation and enforcement of the ETS pending future developments in the litigation. So basically, OSHA is in a wait and see mode. So where is this likely to go? That is usually the situation where Dave Wilson has coached us to say, we go to law school for 3 years to learn how to say 2 words, it depends. And it truly does depend here. It will depend upon the outcome of this lottery and how willing the court is to scrutinize why OSHA says it did what it did. And that's going to boil down to a couple of really important things. It's going to, in order for OSHA to have implemented this ETS, it has to have determined that a grave danger to employees exists and that immediate action is necessary to protect those employees from the danger. So those are going to be key things that courts are going to be looking at: grave danger and necessity. Now, if both have been established, OSHA has almost unlimited discretion to implement a standard that it believes is appropriate to address the danger and in whatever way it thinks best. Now, and as I said, once it's there, the discretion is almost unlimited, but we don't know if it'll get to that point. So do not think right now that ETS has gone away. It has not. It's basically, it's been put on hold, but is simmering with a heavy, heavy boil. Who knows what will happen when the lid gets taken out? But for now, it has not been declared illegal. It is not necessarily going away. So what should you do? No matter whether ETS stays in effect or not, you as employers are going to have a duty to protect your employees no matter what occurs. And so you as institutions, as many have already, should continue to pursue that protection in the way that you think works best for your organization. So Cathy, with that, that's my brief tea leaf reading on that. I'll turn it back over to you.
Hey, Cathy, Cathy, can I ask a question of Scott? So Scott, very, very helpful. Do we have any sense of the timing? I mean, I'm assuming that a more favorable circuit could get charge of this and remove the stay, but probably it ends up at the Supreme Court anyway. I mean, do we have a sense of how long this process could take?
Pete, I don't have a sense of in terms of days or weeks. I will say that we are talking, but if I were to guess, it is that. It is days or weeks. It is not months. These deadlines are coming up, and you're also right. No matter what happens at the appellate level, someone is going to try to get the Supreme Court to take this. And this is one of the reasons why I think that whatever court gets it is going to try to write a decision that it believes is bulletproof. Whether it will in fact be bulletproof is anyone's guess. But I think that we're looking at, as you saw with the speed with which the Fifth Circuit acted. I mean, these things were implemented on November 5th. An overall stay was granted, but 7 days later. We're now in 4 days later, the lottery pick mode. And once the consolidation has occurred, I expect that the briefing is going to go forward fast and furious, notwithstanding the impending Thanksgiving week.
All right. Well, as Scott notes, you have a duty under OSHA to provide a safe workplace. So this ETS, whether it survives or not, is one roadmap for doing so. And it's a roadmap that's created by the organization that has unbelievable experience with the research, with the testing. Jeff Hirsch wrote a book on OSHA and can tell you that they truly, in many ways, know what they are doing and have good ideas. And this is relatively user-friendly. It doesn't work for everyone, but consider whatever policies you have, getting going and incorporating these to the best that you can, so that in those days, weeks, and likely not months, when we have a clear answer, you are ready to rock and roll. So the first question is, are you covered by this thing? And it's 100 or more employees. And that's the way you would think it is. Anybody that's on your payroll is your employee. It's not your different divisions. It's not your different locations. If it's temporary employees, it's part-time employees, it's remote employees. They may not have to be vaccinated if they're truly remote, but they are still counted for the 100. Franchises, there's some rules in there that if, you know, the individual franchise is the individual employer, not the corporate franchisor. Independent contractors, if they're really, truly independent contractors, don't count. We had some clients who said, well, Cathy, can I just rely on EIN number? Generally speaking, yes. Whoever is on the payroll, the entity that's issuing the checks to the employees is the employer, and that's where you do the count. But we're aware that some businesses are set up as a series of little tiny individual businesses, each with its own EIN. And the Department of Labor, of which OSHA is a part, has a proud history of sometimes looking past that. If you've got workers and they're moving from location to location and managers that are supervising multiple locations, the fact that you set it up, each with its own EIN, might not stick. But generally speaking, you're looking as the employer as a whole, and it's the number at any time, any of the 6 months, the standards in effect. If you hit the 100, you're covered. And even if you go down to 99, you're still covered for the entire period of the ETS. Let's go to the next slide. All right, so who are the employers who are not covered? If you're a federal contractor, so we saw somebody put something in the chat about, well, what about those of us who are federal contractors and we're subject to the Safer Federal Workforce Task Force plan that you wrote about in a client alert? You're not subject to this. It's either or. Likewise, if you are subject to the OSHA healthcare ETS that came out some months back, and then recently the Centers for Medicaid and Medicare, CMM, also issued a standard requiring vaccination. Those employers aren't subject to this, they're subject to that. And certain government employees aren't covered, although post office workers are, interestingly enough. So those are the employers who are not covered. But otherwise, private employer, 100 or more, you're covered unless you're a federal contractor or you're covered under one of these healthcare standards. Let's go to the next one. Okay, so certain employees aren't subject to the vaccination and testing requirements. They're still counted towards the 100, but they're not covered if you're really remote, truly remote. You do not report to any workplace where other humans are present. Not partial remote. If you're 100% working off on a site and there's no other human beings that you can breathe on or breathe from them, you don't have to be tested. If you're working from home exclusively, that's a strong word. And then there's also a provision for working exclusively outdoors. Yeah, you can go inside with your mask on and go to the bathroom, but really exclusively outdoors. Otherwise, everybody is covered. Next slide. All right, so now let's turn to Dave to get into the nitty-gritty of what you have to do to comply if you are covered.
Thanks, Cathy. So next slide. So first thing an employer should do is determine who's vaccinated and who's not. Now, fully vaccinated means 2 shots received and 14 days have passed since the second shot, or 14 days have passed since 1 J&J shot. We had a question about booster shots. Booster shots are great, but they're not factored into the ETS. So you're fully vaccinated whether you've had a booster or not, if you've either had the 2 shots and 14 days have passed, or the J&J and 1 have passed. Next slide. So what is acceptable proof of an employee's vaccination status? And the ETS offers 4 types of acceptable proof. They're listed here on the slide. And for you HR folks, think about the I-9. So like an I-9 review, employers don't have to be document experts. If a card looks legitimate, you can accept it. You just can't accept obviously fraudulent documents. And like the I-9, we'd recommend that you make copies and keep all this. In fact, you're required to here, whereas in the I-9, it's an option. But what if an employee comes to you, next slide, and says, my dog ate my homework? And and says, I had the vaccine, but I can't find the proof. Next slide. Well, the OSHA has thought about this issue. And so there's a process for folks if they've lost their proof. And ultimately, what they could do if they can't find the proof or track it down in a number of ways, and the ETS goes into different ways how you can track down the proof, you can have the employee sign a statement that includes the words in the box. I declare that this statement about my vaccination status is true and accurate. I understand that knowingly providing false information regarding my status may subject me to criminal penalties. And so there is a way to handle this, and the employees know that if they have lied on that they'd be subject to penalties. Next slide. Now, if the employee cannot provide proof, you have to treat them as not fully vaccinated. And we'll get into what that means, not fully vaccinated. Now let's talk about what record-keeping rules do you have? Next slide. So again, like the INN records, keep good physical and or digital records. Again, you don't need to be an expert in analyzing the documents, but obvious fraud cannot be condoned. The OSHA talks about treating these like medical records. So they're confidential on a need-to-know basis. Now, remember, one of the things that you're going to be required to do is produce a roster of your employees of who's been vaccinated and who hasn't. So I'm imagining an Excel spreadsheet that lists all your employees, who's been vaccinated and who hasn't. And then for backup for that, you'll actually have the proof for each of those employees, because you may be asked to produce your roster to OSHA. Okay, now let's talk about your options. Next slide. The first option is, hey, we're one slide behind. We just talked about, yeah. First slide is, let's talk about the mandatory vaccination policy. And that is the policy that OSHA would encourage folks to have, basically mandating that everybody be vaccinated. And OSHA, next slide. OSHA has sample policies, so you don't actually have to come up with your own. If you just Google OSHA ETS mandatory vaccination policy template, that will come up, and it sort of lays it out. Next slide, right? And basically that policy requires employees to be fully vaccinated, including all your new employees as soon as practicable. And the only exceptions would be if the vaccine is medically contraindicated, or there's a medical necessity to delay getting vaccinated, or you have to provide a reasonable accommodation under the ADA because of a medical reason or sincerely held religious belief or practice. Next slide. Now, Cathy will talk about, so I've talked about the mandatory vaccination policy. And the beauty of that one is it's a lot administratively, a lot simpler. You're just requiring everybody to be vaccinated. Cathy's now going to talk to us about the other option.
All right. So this is the only alternative to adopting a mandatory vaccination policy. So if you don't have a mandatory vaccination policy, then you're going to have a policy that allows employees to choose whether to be fully vaccinated or provide you with proof that they are getting regular testing, and you force them to wear a face covering. So as Dave got into, this is an option for you, and this may be the best option for you for maintaining your workforce due to tough staffing issues and hiring issues, but there's a lot more procedural rigmarole for the employer if we go this option B. All right, next slide. Okay, so this is the big thing, is you must ensure, and Anybody who's worked with me know whenever you give me an employee handbook to review and you've got the word ensure there, I take out that word because that word wigs me out because it's a tough thing to ensure something. But that's what this standard says. You must ensure that anybody who reports to the workplace that has other human beings around, they've got to give you proof of a negative test one time every 7 days. And if they're not coming to the workforce regularly, then they can't come into the workforce unless they've been tested within 7 days. So the deadline for you to ensure all of this is January 4th. Of course, the deadline for you to adopt the policy is December, when you tell people that this is required. Next slide. All right? If they don't give you the piece of paper that says they've been tested, you must keep them out of the workplace. Now, what do you do while they're out of the workplace? Some employers are going to say, you know, if you don't give me the test results in the 7 days, you can't work. Maybe they could remote work. Maybe they could use a vacation day, but you, the employer, have to decide. Some of our clients are saying, I don't want to deal with that. I don't want people taking little vacation days here and there. I don't want to chase after people. If they don't come in with the test, they're put on unpaid leave, period. Or maybe they're even terminated. You're going to have to make a decision as to what's best for you. They've got to give you that record. You've got to keep those test results and keep the record of it. It's confidential medical records. You don't stick that in their personnel file, but you have to have the record. And if they get a positive test, so this little bit here is that, so they're getting tested weekly, every 7 days. If someone gets a positive test, they have to be removed from the workplace and then they can be put back after the doctor clears them. But after the doctor clears them, they may continue to test positive for a couple of months. And so what OSHA is saying here is, look, if you had the positive test and you were cleared to return to work, we're not going to make that employee go through all these tests and get all these false positives, but they do have to wear a face covering. And so just a little recognition by OSHA about the vicissitudes of testing. All right, so you gotta have people tested. Next slide. So what are the acceptable tests? It's all the usual ones that we know about. It's the antigen test, it's the antibody test, but it's gotta be administered and approved. It's approved, administered in the way it's approved to be. Some of our clients are saying, well, what about those home testing kits? You know, those are very convenient. You can't do a self-administered test unless you, the employer, are there watching the person stick the thing in their nose and put the little droplets on, or there's an authorized telehealth proctor doing that. The reason for that is just to be too easy for employees to say, oh, well, I was tested, I did a home test. So there's a limit to that. So home test, then there's, you ever heard the pool testing? A lot of the colleges and universities are doing that. Everybody goes in, they get all these samples, and if 150 people, everybody's negative, you know that you're great. But if you do that and there's one positive, then everybody's going to have to be tested. All right, next slide. Actually, let's go back to the last slide because I might have said something wrong in terms of the tests. I said the antigen tests are okay, but antibody tests, in other words, the fact that you've had COVID before and you've built up antibodies to it, that is not an acceptable test. So if I suggested that a second ago, I misspoke, all right? So it's very clear in the ETS what types of tests are allowed. Right, next slide. Okay, if a person is not fully vaccinated, if they're not, in addition to getting them tested every week, you must make sure they wear face coverings anytime they're inside or anytime they're in front of other human beings. And what are the only exceptions? Not a cubicle. It's got to be if you're alone in a room with floor to ceiling walls. Those words are right in there, floor to ceiling. Yeah, you know, you can take it off to show for identification or to quickly have a cup of coffee or eat your lunch. But otherwise, you have to keep that thing on at all times unless you're vaccinated. If you're vaccinated, then OSHA doesn't require you to wear the face covering. City of Boston might, you know, your state, other states might, there might be local authorities that require it if you're in a high transmission area. But if a person is vaccinated, OSHA doesn't care. But if they're unvaccinated, they must wear that mask, unless you can show that there's some reason it's totally infeasible or impossible, causing danger. And there's even some provisions in there about persons who are hard of hearing and they need to be able to see people's lips and having a plastic shield for that. Let's go to the next one. All right, so what's an acceptable face covering? OSHA gets into this in detail, and all the surgical masks, those are fine. The gaiters are okay if it's 2 layers, but it's got to be secured. None of this hanging off the bottom of the nose thing. You, of the employer, have to make sure that people keep these things on, that there aren't those little valves in it, the breathe out valves. That defeats the purpose. It's a solid piece of material. And again, the employer is responsible for enforcing people who are not vaccinated to wear these face coverings. Next slide. All right, so you got to ensure it, that they fully cover it. You can't prevent, so someone is vaccinated, you can't prevent them from wearing a mask. You can't prevent people from wearing it if they want to wear it. A lot of people may choose to wear a mask even if they are vaccinated. And in some locations, they may be required to under local ordinances. We've had questions about what about customers and visitors? That's up to you. That's not covered by OSHA, but you have a duty to provide a safe workplace. And if you let people come into your facility in the middle of a huge outbreak and you don't require them to wear a face covering or show proof of vaccination, you are creating a safety risk for your employees. So feel free to consult with us about developing policies related to customers and visitors. But OSHA doesn't require you to get proof. You know, if you're a theater and you have people show a card, the theaters aren't collecting those cards. Whereas with your employees, you must keep that proof. Next one. All right, a lot of questions about, well, who covers the cost of these face coverings? OSHA says, you don't have to pay for these face coverings, but might be required under a collective bargaining agreement, or it might be required under Massachusetts or state law. Well, what does Massachusetts say? Massachusetts has not answered this question. So we have sent a letter to the Attorney General saying, can you just clarify what we think is the case? Here's what we think is the case. We think Massachusetts would see a face covering like a pair of shoes. An employer can say, you need to come to work and you need to wear shoes, but the employer doesn't need to provide the shoes. But if an employer has a required uniform and you say you must wear a particular type of face covering, a respirator that we're providing as PPE, or a specific face covering that has our logo or does something, if you mandate it like a uniform, you're going to have to pay for it. That's our opinion. But if it's just come into work with a face covering that complies with the standard, our view is that Massachusetts would not require you to pay for it. And hopefully the Attorney General will give us a little guidance, and it will be the guidance consistent with what we're advising folks. All right, next slide. What about the testing? Who pays for the testing? Once again, OSHA says we don't require paying for the testing, but maybe your union will, maybe your state will. So once again, what would Massachusetts say? There's a statute in Massachusetts that says if you require an employee to get a medical test at a physician designated by you, then you have to pay for it. So if you just say go out and get a test, you don't have to pay for it. But if you have testing facilities on site and you make people go to that particular testing facility, then you're going to have to pay for it. And you might have to pay for it depending on what's in your collective bargaining agreement, as Pete's going to talk about. Next slide. Next slide. And this is, what about the time that is spent testing? Is that work time? What do we think the Attorney General would say about that? Well, we have a little clue here because their prior guidance regarding vaccination, which is a little different than testing, basically said, well, look, if you're making them go get vaccinated during working hours, then it's working time. If you make them get their vaccine at a specific location or a test at a specific location, it's working time. But if you just say, look, in order to work here, you must give us proof that you've done this, then it's not working time. And then they also say, but if you want an opinion, you can write to us. And we have written and we haven't had an answer. And maybe that's better because we can act in good faith on what we think is the case, which is that no, unless you're forcing them to do it on site, you don't have to pay for that time. Next slide. All right, here's some more timing issues. Dave, take it from here.
Yeah, so let's remember the OSHA's goal is to get folks vaccinated. So they don't want any financial barriers to prevent employees from getting tested. So employers must provide a reasonable amount of time for employees to get their primary vaccination dose and up to 4 hours of paid time, including their travel time at their regular rate. And you can't require them to use sick time. You can't offset those 4 hours. Just remember, the goal here is to get folks vaccinated and don't create any financial barriers. So that's what the ETS is, and that's why you even need to pay for their transportation costs to get there. So now let's say I get jabbed and I feel lousy. Let's go to the next slide. Again, for the same reason, OSHA doesn't want to create any negative, any barrier to getting the shot. So if you have a negative reaction, we need to give the employee time off to recover. And in most cases, be paid for it. So again, reasonable time off, and I can use my paid sick time to recover. And the employer can't put a cap on my recovery time, but you know, I can't be out for a month recovering from my shot. And so really, if you look at it, the goal here again is let's not create any financial barriers to somebody getting the shot. So paying for the time to go get it and paying for the recovery time. Next slide. Cathy, I think this is you.
I was typing out an answer to a Q&A. The Q&A is great, by the way. We appreciate the folks that are asking. All right, so you have to educate your workforce about the new ETS. So there are 5 things that you have to give them, and all of them are pretty much available on the OSHA website, so don't panic. And you got to do it in a language and literacy level that they can understand. So first of all, just information about this ETS, and there's an OSHA fact sheet that you can give them, and they've got it translated into some languages. You have to give them a copy of the policy that you develop. And OSHA, by the way, has 2 template policies right on the website that cover everything that you need to include. You just have to fill in the blanks. The one thing that those template policies don't cover is reasonable accommodation. They kind of punt. They just say, insert procedures for reasonable accommodation here. But Janette's going to give you some information about that, and counsel can help you with that. You have to give them this document from the CDC called Key Things to Know About COVID-19 Vaccines. And you just Google those words, it pops right up. It's good stuff. It'll be useful for your employees. You have to give them a sheet that talks about their rights. That says they have rights under OSHA to non-retaliation. An employee can come to you with good faith safety concerns. You can't fire them for doing that, even if they're wrong about their safety concern. Can't retaliate. But this last one's really interesting. So as Dave said, with respect to determining vaccine status, well, how do you know if someone is showing you a card that they got on the internet? Well, if it's not obvious that they did so, you, the employer, don't have to verify and double check, but you have to tell all your workers in writing that, hey guys, if you lie about this, you could go to jail. I mean, that's sort of in the vernacular, but that's what it is. It's criminal penalties. You inform your workers that they need to be truthful, and if they're not, there can be bad consequences for them. All right, next slide. So this is a requirement that says if someone tests positive, they've got to tell you promptly. That means as soon as they can before they come back into the office. All right, and then they must be immediately removed from the workplace. If they test positive, they've got to be removed. And they stay removed until either they meet the return to work criteria and the isolation guidance. What's that's all about? That's the, that's the 14 days, or is it the 10 days? It's a certain number of days after the person has had symptoms. And I think it's 24 hours where they haven't had any fever and they're not doing fever reducing drugs. It's all the stuff that we've been doing all along. Or they get a doctor's note that says it's fine for them to come back. And this number 1 just is any old negative. Oh, if they get a negative test, they can come back. It's not that simple with respect to just a negative test, because if they receive if their first test was this NAAT test, which is a positive test, the more robust test, then they have to follow those isolation guidance. But if the positive test was an antigen test, OSHA says, well, we get a lot of false positives with that. So if you get the more robust test and it says they're negative, that's okay. Just the main thing to require is that with a positive test, you've got to go through that isolation rigmarole. It's not just a matter of, oh, get a negative test and you're home free. You need something from the doctor. The home free is only if the positive test might have been a false positive. Okay, next slide. So what happens? You remove them from the workplace and now they're not working. You have to pay them for that time. And OSHA says, not according to us, but once again, you might have to pay them under your collective bargaining agreement, or you might have to pay them under state law. So what about Massachusetts law? Are there any laws in Massachusetts that require employees to be given time off because they've been removed from the workplace? Well, yeah, you may have a vacation policy. There may be COVID emergency leave. There may be the Paid Family Medical Leave Act. There may be the Mass Sick Leave Law. So you remove them from the workplace, but they may be entitled to paid time for that under other requirements that you have. You can have them telework if you like, but they've got to be removed from the workplace so that they are not potentially spreading COVID. And there's nothing in this ETS about contact tracing. Now, Scott says you still got to provide a safe workplace, and if you know an employee is positive, do you want to do what we've been doing all along, which is not tell anybody the name of that employee, but tell other workers, hey, someone in this building did test positive, so we suggest you might want to get tested. You don't, under the OSHA standard, have to remove them. All right, go to the people who were sitting next to them. Under OSHA, we already know this. Oh, working work fatalities. OSHA requires, and has always required, that you report work-related hospitalizations and fatalities. But under this ETS, if you have a case of COVID that appears to be work-related, the person is sitting next to somebody else and then 2 days later, they test positive as well, or it's a healthcare type setting, if there's reason to believe that this was contracted at work, you have to tell OSHA, and you have to tell OSHA a lot faster than you would with regard to other types of reporting. It's a very robust standard. And you also got to report it to your workers' compensation carrier, and they may have some thoughts as to whether it's truly work-related. It's kind of a hot button issue, and OSHA a little bit punts on it and says, well, you figure it out. So if someone contracts COVID, there's reason to believe is at work, you have to report it. And OSHA might come in and do an investigation and want to see a copy of your policy, and of course, you'll have it handy and ready to go. All right, next slide. Lots of record keeping under this thing. It's not rocket science, but you have to turn it around pretty fast. So if an employee, an individual employee or a union wants to know information about who's vaccinated and who's not, can you tell them? All you can tell them is we have this many, you have to tell them, we have this many employees and this many are vaccinated. So 63 out of 120 are vaccinated. Unions and employees have the right to know that, and they have the right to know their own vaccination status, an individual worker. But beyond that, vaccination, the roster, everybody's name, and who's vaccinated, who isn't, that's available for OSHA, but not available for individual workers. Some clients have said to us, well, what about that roster? Do I give that roster to the managers so that they know who is to be masked? And the answer is do a need to know basis with as little information as possible. Like to say to a manager, here's a list of the employees that are going to be required to wear a mask. The manager doesn't have to know why. Is it because they're not vaccinated? Is it because they have a medical exemption? Is it because they have a religious exemption? Because they want to wear it? Just give them a list as to who they must ensure is wearing a mask. You got to have your policy ready to give to OSHA. You got to have those records of testing. Again, keep them separate from personnel records, but keep them all together. OSHA may come in and say, we want to see that proof of vaccine, and we want to see that proof that anybody who's not vaccinated got the test. All right, weekly. Next slide. Okay, so Janette, we have all this information from OSHA, but the one thing they didn't cover was medical and religious exemptions other than to say, you might have to grant them. Please tell us all more.
Thanks, Cathy. Exactly. Due to the increase of mandatory vaccination policies, I know many of you are wondering, how do we navigate requests for exemptions from taking the vaccine? As an employer, if you have issued a mandatory vaccination policy, your policy should inform employees that they can request an exemption from the vaccine due to religious or medical reasons. Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, and Massachusetts law require an employer to provide reasonable accommodations for employees who, because of a disability or a sincerely held religious belief, practice, or observance, cannot get vaccinated against COVID-19, unless providing an accommodation would pose an undue hardship on the operation of the employer's business. Next slide, please. First, let's address exemption requests on the basis of religion. As I just mentioned, Title VII of the Civil Rights Act of 1964 and Massachusetts law prohibit employment discrimination based on religion. This means that employees can request a reasonable accommodation from the mandatory vaccination requirement if it conflicts with their sincerely held religious beliefs. EEOC guidance and federal and state case law tell us that the definition of religion is broad and it protects beliefs, practices, and observances, including religious beliefs which you may not be familiar with. Now, this is really key because this means that just because you've never heard of a religion, it doesn't mean that the religious beliefs are not sincerely held. The definition of religion under Title VII protects non-traditional religious beliefs. Next slide, please. We recommend that along with the mandatory vaccination policy, you include an exemption request form. This form should be used for religious and medical exemptions, and I'll cover the medical exemptions in a few minutes. The exemption request form will allow an employee to request an exemption on the basis of religious grounds, and the form will allow an employee to actually describe how the COVID-19 vaccination would require them to go against their religious beliefs. So as the employer, you should ordinarily assume that an employee's request for religious accommodation is based on a sincerely held religious belief. However, if an employee requests a religious accommodation and you are aware of facts that provide an objective basis for questioning either the religious nature or the sincerity of the religious beliefs, you could request additional documentation. So for example, perhaps an employee requested an exemption from the policy because of political reasons, and then after that didn't work, they've now requested an exemption from the policy on religious grounds. That may make you suspicious that their beliefs are not actually sincerely held, and this could be a reason to request more documentation. But keep in mind, as I said, that generally speaking, the sincerity of an employee's stated religious beliefs is not usually in dispute. Once an employee has requested an exemption, the employee and employer should engage in an interactive dialogue to determine a reasonable accommodation. According to OSHA, at a minimum, the accommodation must include testing and face covering. But like any accommodation request, the analysis of determining the accommodation must be done on a case-by-case basis, considering the employee's job duties, and if the accommodation poses an undue hardship to the employer. And I'll get into the undue hardship analysis in a few minutes as well. So when we send out materials from the roundtable today, we will include a sample exemption request form. Next slide, please. Requests for medical exemptions follow a similar analysis as the request for religious exemptions. You should, along with the vaccination policy, provide a form that employees can fill out to request the medical exemption that states the grounds for the exemption. And the form should also include a healthcare provider certification in which the healthcare provider explains the medical reasons why the employee cannot get the COVID-19 vaccination. Once the employee and the healthcare provider have filled out the form, and if you've determined that the exemption request is legitimate, you must engage in the interactive dialogue with the employee to determine an appropriate accommodation. For example, a reasonable accommodation, and as a reasonable accommodation, an unvaccinated employee entering the workplace, in addition to wearing a face mask or face covering and getting periodic testing, may work at a social distance from coworkers or non-employees, work a modified shift. Possibly they could be given the opportunity to work remotely or to even accept reassignment. As with the religious requests, the employer must consider all possible accommodations that do not pose an undue hardship on the employer. Next slide, please. When determining if a reasonable accommodation poses an undue hardship, remember that undue hardship can be both economic costs, such as lost business or having to hire additional employees, and non-economic costs, such as loosening your dress code. Also, keep in mind that there is a slightly different standard between the undue hardship analysis between accommodation requests based off of religious beliefs and accommodation requests due to disability or medical. And so for this reason, it's actually harder for an employer to show undue hardship for an employee who has requested an accommodation on the basis of a disability. So you should, when you're doing the undue hardship analysis, it's best to consult with counsel before making any determinations about undue hardship. Generally, as the employer, you should thoroughly consider all reasonable accommodations, including remote work and job reassignments before taking any adverse action against an employee. If a job reassignment is not possible, you may even want to consider allowing the employee to resign voluntarily, which may allow them to reapply for a position if circumstances change. And I guess with that, I'll now pass it over to Pete to discuss unions.
Unless, Scott, is there anything you want to add on this issue of religious accommodation and what seems fair and what seems not?
Yeah, I think that Janette's put her finger on it. You wade into troubling waters when you start to challenge the lack of sincerity of a particular religious belief. She's right. There may be situations where you can find objective evidence that that a request is not based upon a true religious belief, but rather a political one. I think in those situations, particularly in medical institutions, food service institutions, and the like, it may be that that the best argument in terms of denying a request for religious exemptions is to focus on the undue hardship piece, meaning that it simply won't work given what the person does. But I don't think anyone's going to do themselves a great service in trying to debate the sincerity of a religious belief just because they haven't heard of the religion or curious or skeptical of the belief. There's got to be a good basis to do that.
All right, thank you,
Good
Scott.
points.
So, Pete, those with unions, do we now have like two people to fight with, OSHA and the union?
Those with unions, yeah. And let me dwell one more moment on this, Janette's topic, this religious accommodation. We've been going fast and furious through all the requirements of this new law, which is temporarily on hold. I just want to reinforce a few sort of key points. A lot of folks on this call, a lot of clients have already rolled out their mandatory vaccination policies or some version of it. This mishigas over the new law is not a judgment about whether an employer can have its own mandatory vaccination policy. This is about OSHA's authority to issue the law. So chances are, a lot of employers have already thought about this issue and have already taken a stand one way or the other on mandatory vaccination or not, particularly if you've gone the mandatory vaccination route. This doesn't necessarily change that. You may want to update your current policy to make sure it's in compliance with what we anticipate might be the law coming back again down the road. But this doesn't say anything about the need to sort of walk back a mandatory vaccination policy. And I think we all know this on this call. One of the points I wanted to emphasize on that, though, is many of you have probably already been dealing with religious accommodation requests. We've been fielding those phone calls for months and months and months. The analysis hasn't changed. To Cathy or Dave, whoever talked about this initially, this law doesn't even get into it. It just says, follow the law, follow the other federal law in this regard. So we've been dealing with religious accommodation requests. You guys probably haven't too. The analysis really hasn't changed because of this law, nor has your ability to continue to maintain a mandatory vaccination policy. It's just that you might want to make sure it conforms with some of the new wrinkles of this law. So I wanted to get that out. And in sort of that vein, there's so much, confusion whenever a big new pronouncement like this new OSHA ETS comes out. And as Scott had said earlier, there's a lot of pundits out there, or so-called pundits, that are spinning things a certain way. This is so wrapped up in politics. If we're all confused, if HR professionals, attorneys have sort of got to really dig into this and put deep into it to try and harmonize the different requirements that are out there, your employees are confused about this and getting information from some potentially questionable sources. If you've got the kind of workplace, and not all of them are like this, but if you've got the kind of workplace where this is a hot topic, where you got some people with strongly held beliefs about vaccination, and it's been a divisive thing in your workplace, and people would love nothing better than to hear that, mandatory vaccination is illegal, it may behoove you to get out a communication and get ahead of this. We haven't talked about communication on this program yet, but for some employers, it may make sense to say, hey, workforce, you may have been hearing a lot in the news about this new law. Let me tell you what's going on and how this intersects with our current policy. So, topic for a different day. We don't need to be communication and PR experts on this webinar, but I wanted to at least flag that if we have questions, as HR professionals, your employees have questions, and for some workforces, it's a good opportunity to sort of do a little bit of a reset and reminder, like, hey, here's what our policy says. Here's why we rolled it out. Here's what's going on with the law that you may have been hearing about. If you have any questions, let us know, just to sort of calm any waters that might be roiling. So I wanted to say all that before jumping into this much more narrow issue about unions. If we were in a live program, I'd pause and say, any questions? Because I'm sure there have been a lot of questions flying in. I know our guys have been trying to answer them on the fly. But let's do a pivot and talk about unions. So enter another agency. And, not to get all political, but this is part of why this stuff is so hot.
Let's go to the next slide. Let's just go to the next slide.
Sure, yeah. So duty to bargain with unions. Here's the new agency I was talking about, the NLRB, the National Labor Relations Board. So they got into the act a few days ago through a memo. On November 10th, the NLRB, the folks that, the federal agency that deals with labor law, labor issues, unions, came out with a memo from the General Counsel's office. Interestingly, an operations management memo, which is normally just reserved for administrative stuff. Suddenly they come out with this operations management memo that's dealing with substance, which is unusual. That would usually come in the form of a different memo, a GC memo. So there's all sorts of weird layers of stuff going on here. But anyway, as if we didn't have enough agencies to worry about, with OSHA being the one to come out with this, with the EEOC having something to say about religious accommodations, with other agencies, the Medicaid and Medicare doing their own thing. Now we've got another agency coming in and saying its part. And we'll start with this. What did the NLRB have to say about this new OSHA requirement? Well, what Dave said earlier, or what somebody referenced Dave saying earlier, was it depends, So the questions that, anybody with a unionized workforce is probably asking themselves. I wrote down 4. So I wanted to at least touch on the 4 questions that a unionized employer is probably asking themselves with respect to this new OSHA requirement. 1, is there a duty to bargain about it? 2, if so, what is there to bargain about? 3, what if we go into bargaining and can't agree? What happens then? And 4, okay, if I got to talk to the union, what do you recommend as to how we go about doing it? So let me just try and tick off those real quickly. I know we're sort of on the back end of the program, but is there a duty to bargain? And this is what the NLRB was primarily weighing in about. And the short answer is yes, probably, but it's more complicated than that. So if you have a unionized workforce, there are discretionary pieces of this new requirement. It's not as if a legal mandate comes down and there's no discretion to it and you got to follow it, there's nothing to bargain about. And you see that come up in some places. Sometimes in human services, maybe the state comes out and says, you human services agency are just a pass through. We want you to give this money, to your employees in the form of hazard pay. It's going to be X amount per hour. It's going to be whatever it is. There's no discretion to it. We got to do it. There's nothing to bargain about with the union. The union may want to have a say in it, but there's nothing to talk about. So if you have a true federal mandate, a state mandate, some legal requirement that you just have to do and there's no discretion in it, that's not bargainable. But usually there's some discretion in the mandate, and that's what the NLRB is saying is going on with OSHA. They're saying, yeah, that's a new requirement, but there's discretion here. You could have a mandatory vaccination policy, or you could go option B and have it involve testing and masking. So now it's discretionary. So now management, because we're talking about terms and conditions of employment, bargain with your union about that. So that's the main thrust of what the NLRB has said is, hey, there's discretion in here. You got to bargain about it, but there's always caveats to the caveats. And so as a unionized employer, the first thing you do is you check your collective bargaining agreement. And, you know, admittedly, this would come up more with healthcare institutions, probably. Folks who've done flu vaccines in the past, who've got sort of a history of doing vaccinations. And those guys are maybe not covered by this OSHA standard because they're covered by a different federal standard. But if you look at your collective bargaining agreement in the management rights clause or in the health and safety clause, and it says, you know, management reserves the right to implement rules and policies to ensure the health and safety of employees, including vaccination, or even not including vaccination. There's an argument that that language in the CBA actually allows you to roll out the new mandatory vaccination policy without having to bargain about the decision to do so. So note that word decision. So let me start from the beginning again. The NLRB says, hey, this law has discretion. Therefore, unionized employers, you've got to bargain with the union about some of this stuff. Check your contract because it could be pre-bargained. Essentially, the union could have waived its right to bargain further about this issue because it's already been bargained. So for some employers, that's possible. But then if you have to bargain, sometimes the question comes down to, well, what am I bargaining? Am I bargaining about the decision to roll out a mandatory vaccination policy, or am I bargaining sort of about the effects of it, the details of it? And so the NLRB makes clear that, and this is nothing new, this is not surprising, and this is sort of a common framework, and those with unions will be very familiar with the terminology. It may well be that we don't have to bargain the decision to roll out a mandatory vaccination policy, but you've got to bargain with the union about the effects or the impacts of that decision. It's called effects bargaining or impact bargaining. What could the impacts be? Well, who pays for the mask? You know, what if I'm, sick because of the vaccine? Am I going to get paid time out or not paid time out? What happens if I can't get vaccinated? Do I have a right to be recalled or rehired? You know, if I change my mind or something changes down the road. But there's plenty of what I would call details, but what the labor law would call impacts or effects of this law that's different from the decision to roll out the law, the policy in this case itself. So that's the answer to the few questions I started teeing up. One, is there a duty to bargain with unions about this? Isn't this just a federal requirement we have to follow? Not really, because there's such discretion built in there. There's details that you can't just unilaterally implement unless you've already got the right to do so in your contract. And that right should be pretty clearly spelled out, but that's sort of a niche area of the law that you'd have to talk about with us one-on-one. But yeah, there's probably a duty to bargain, even if it's only about the effects. What's there to bargain about? Well, it could be on that realm, like I said, the impact bargaining. And what if we can't agree? This is where it kind of gets weird. And this is where people get frustrated with our government. The fourth branch of government. When we were growing up and took our civics classes, we had the executive, judicial, legislative branches, and that was it. And over the decades, more and more so, this so-called fourth branch of government comes in. Everything, all these rules and requirements and laws, really, for lack of a better word, it's not laws, but they feel like it, come from the agencies. And that's part of the problem here. And that's where the legal challenge to OSHA is coming from, because has OSHA exceeded its authority? And employers get very frustrated when different agencies are saying different things. We had recently last year, OSHA and the EEOC going at it. I don't know if people were following this one, but, the EEOC, takes a very strong position requiring employers to prevent discrimination in the workplace. And if you've got somebody that's uttering offensive comments, maybe racist comments, OSHA, the EEOC would say, you got to deal with that. You got to remedy that situation. That's the legal liability. OSHA comes in and says, well, no, not if it's about a labor dispute. It's okay to make racist remarks in a labor dispute. You go, what? Employers are going, that can't be. And so you have these agencies sometimes saying different things because they're coming at it from different directions. And so we kind of have that here too, which is frustrating for employers. Now you've got OSHA coming in and saying, oh my God, it's an urgency. We're going to save 250,000 hospitalizations. We're going to save thousands of lives. This is important. And then the EEOC says, but wait a minute, if somebody's got a religious belief and don't even question the sincerity of it, maybe it's not so important. You go, well, which is the NLRB is saying, yeah, it's important, but you got to bargain with the union about it. And what happens if you can't agree? I don't know. So it's really, it's odd. And it's a part of the frustration and challenges here is it's created by these competing agencies saying different things. So for what it's worth, what has the NLRB said on that last issue? What have they said? We know they've said, look, there's stuff to bargain with your union in this law. There's details, there's discretion. You're going to have to, can't avoid the union just rolls this out. There's going to be impacts at least to bargain about, unless miraculously it's covered in your contract pretty clearly. But man, I lost my, I was coming to that.
The union can't contract out of this thing. In other words, this ETS is a baseline. The union might demand more, but you can't agree with the union to not do the testing. Is that
so that's it, yeah. Well, yeah, there's that. I mean, but I was going to say is what happens if the union doesn't agree? And unions are like the country. Unions have, dozens, hundreds, thousands of members that don't always agree. And so the union isn't always speaking with one voice either. And they're kind of scattered on this stuff. Some unions have come out with statements saying, we're in favor of vaccination, but they've got individual members who aren't. And so if you're stuck dealing with the union on the topic of a mandatory vaccination policy, there may be heel dragging going on. The union's in a tough place to say, yeah, we agree with you. We agree with that policy. Go for it, mandatory vaccination, because half of their membership might be opposed to it. So the question that I have, if I'm representing a unionized employer is, okay, I get it, NLRB. I've got to bargain with the union over this. What happens if we can't reach agreement? What happens if the union just sort of isn't really interested in talking that much, or is just talking in circles? And so the NLRB very helpfully says it depends. They literally said, if you talk with the union about this and reach impasse, whether you can unilaterally implement what you want to do, employer, kind of depends. That's the general counsel of the NLRB's advice to all its regions across the country. So it doesn't really answer the question, but normally, if you're talking with the union midterm in a contract about something you have to bargain about, whether it affects a decision, and it's not directly contravening the contract, you bargain to impasse, and then the employer has the right to unilaterally implement. And it doesn't mean you have to bargain for months and months and months and months. Sometimes it can be pretty quick conversation, but that's normally the way things work, is to say, look, fine, we've got to talk with the union about whatever issue it might be. In this case, perhaps the details and the impacts of this policy. If we can't reach agreement, if we truly come to an end game, if further discussion is futile, the employer normally has the ability to unilaterally implement its offer on this. And that may be where this stuff heads, but the NLRB was sort of very unclear in saying what happens if you reach impasse. It was very much it depends on the facts. So where does that leave us? I said I was going to try and touch on 4 questions. 1 is there a duty to bargain? 2 is what do you bargain about? 3, what happens if you can't agree? 4 is what's the recommended process? If you were an employer right now with a union and you hadn't already rolled out a mandatory vaccination policy or something like that, and now we're saying, geez, we can't avoid this now. Now we gotta do something because this law is coming down the pike, or you know what, this gives us the excuse we need to really deal with this right now. What is the recommended process? I would say this, you give a notice and an opportunity for the union to bargain. You don't go hat in hand to the union and say, hey, we got to talk about this thing. Because as I say, 1, that's normally not a good idea, but 2, especially here where the union it's so tough for a union to speak with one voice on this. You need to steer the conversation. And so the way to do this, which is the way you would normally do something midterm anyway, that required bargaining, is to say to the union, hey, here's the policy that we want to roll out in light of these new requirements. Giving you a heads up, if you have any questions or concerns or want to discuss, let us know. Although we'd love to roll this out, January 1st, or whatever the dates are. And the union has to request bargaining. And most unions would, some unions might not. So the union actually has to request bargaining before you've got an obligation to bargain. And so you tee it up and you say, here's what we want to do. I'm not saying it's a fait accompli, but we've given a lot of thought to this. Here's what we think is right for the workforce. Here's what we intend to do. Let us know if you have any questions or concerns or want to discuss, meaning if you want to request bargaining. And then the union writes back and says, you can't do this. You got to bargain the decision. And we would say, well, we disagree about the decision, but let's talk. let's talk about the effects and the impacts. And you would get that conversation going, but you have to steer. You have to be clear about what you think is right for the workforce to really have to maximize the chances that this ends with some finality and some agreement on it. The more open-ended you present it to the union, and the more you're looking for, a collaborative discussion and consensus, I think with most unions, the less likely it is you're going to get there. You've really got to try and shape the discussion a little bit. But that's 15 minutes of labor law on this topic squeezed in. Is there a duty to bargain? Yeah, you cannot just steamroll past the union on something like this. There's details, there's discretion built into this law. What is there to bargain about? Hopefully just the impacts, but it kind of depends. We'd have to look at all that, and particularly look at your contract. What if we can't agree? Well, we would take the position that we can impasse upon, we can unilaterally implement upon impasse, but the NLRB was a little wishy-washier than that. And what's the process? Lead it, steer it, present what we want to do to the union, let them request bargaining, and then pretty quickly have a process of discussing it and trying to reach an end game with them. So that is all I got. If anybody's got any questions or anything on the labor stuff, I can't put them in the chat, I guess, or the Q&A. We'll try and deal with them.
So Pete, this is an example where, boy, wouldn't it be nice if before then you had Pete as your lawyer and you had a really robust management rights clause that basically said we, the employer, have the right to implement anything that we're legally required to do. I'm thinking about like the paid family and medical leave contributions with some unions would say, well, you can't just take that money out of our paycheck. You have to bargain about that. And sometimes those management rights clauses really made the difference, huh?
Yeah, and if you want to get really wonky about this stuff, for the labor law lovers in the room, this issue itself is in flux. For years and years, the problem with the NLRB, with all these agencies, I'm going to be political again for the moment, is that they are political. And the NLRB is sort of the most political bunch. And they just change their mind. Unlike OSHA, they don't issue standards. It all just depends on who's in charge and the makeup of the NLRB. But on this issue, this could be a critical issue for this policy rollout does my contract actually give me the right to do this? Does my collective bargaining agreement actually give me the right to roll out this policy? I know I got to bargain about it, but is it pre-bargain? Has the union already waived its right to bargain on this based on what I'm seeing in my contract? And that issue itself is sort of in sway. 2 years ago, 2 years ago, the NLRB came out with a very helpful decision for employers under the Trump administration, which really expanded that notion of what's covered in a contract. And they changed the standard. It used to be what's called, there must be a clear and unmistakable waiver from the union in order for the employer to say, I don't have to bargain with you about that. It's got to really be clear and unmistakable in the contract. Like as if the union were saying, here is the issue X, I hereby waive my right to bargain about it. It had to be that clear or else you were stuck mid-term bargaining. In 2019, the Trump NLRB comes out and says, forget all that. We're throwing away all that history. Now it's called the contract coverage standard. If it's covered by what you've talked about in the contract, you don't have to bargain about it anymore. It's already pre-bargained. Everyone assumes that the Biden NLRB, which is now in full form of 5 members as of July, is going to throw that out too. But if this issue were to come up right now under current board law, there'd be a favorable employer standard as to whether your contract language was covered this issue. I expect in the next year that law will change. So
like the weather in Massachusetts. If you don't like the weather in Massachusetts, just wait. And we've got a similar thing with the NLRB. Thank you, Pete. That was fascinating. And thanks to all the presenters.
Yeah, I just want to touch on 2 points before we let folks go. So I did talk about time off for vaccine, no barriers to finance, but employers do not need to pay for transportation costs. So you don't have to pay for gas. You don't have to pay their bus fare. If they telework and they come into the office to get a jab, you don't have to pay for that. I just want to be clear on that. The other is a number of questions we got was about, well, even if the OSHA ETS is on hold, can we as employers go ahead and implement a mandatory vaccination policy, or can we start collecting proof of vaccines? And the answer is absolutely yes. And many employers have already implemented mandatory vaccination policies and are doing it. OSHA's given you a blueprint of how to go forward with this. So you certainly can go ahead, whether this gets tied up in court or not.
You know, I'm so glad you mentioned that, Dave, because there in the Q&A, we've been answering questions as they've come in, but I want to let everybody know we are going to send out the PowerPoint slides. We're going to send out a more robust version of the Q&A. In other words, we gave quickie answers off the top of our heads while the questions were coming in, but we will provide more in-depth answers to those questions. We had a number of questions about federal contractors. They're not subject to this standard. They have a different standard, but we've got a client alert out on that standard, and we'll include that in the Q&A answers for you as well. Another thing we are getting a lot of questions about in the Q&A, which Dave covered, but I want to reiterate is, well, this business of when can I force them to use their paid time off and when can't I? If it's time off for the vaccine itself, you got to give them up to 4 hours paid, and you cannot require them to use their PTO, their sick leave, their personal, all that stuff. That's time off for the vaccine. If it's time off for recovery from the vaccine, they got the vaccine, and a lot of friends of mine are finding sometimes with the booster shots, it's you know, felling them a little bit more. Time off for recovery, you can make them use their paid sick time. But if they don't have any paid sick time left, you can't make them sort of go into the negative balance. You've got to give them that reasonable paid time off. All right, so in our remaining 9 minutes, let's see what other questions we have. Will you please send an exemption request form? Yes, we will send you a sample exemption request form. It's not legal advice, it's one possible approach. Some of you folks on the call also attended a fantastic webinar on this subject by Eastern Benefits. They've also developed a terrific, robust vaccination exemption form. So there's different approaches to take, but we do have an all-in-one form that we've come up, and we will give it to you. All right, so here's this. Is the employer responsible for paying a time minimum to the employee for completing the attestation form, which takes less than 5 seconds, but must be completed half hour before entering the workplace? I sort of see this as one of these questions. I think the person is assuming the answer. And just keep it this way. If you are requiring someone to do something during their work hours connected with this ETS, you should pay them for the time. But no, if you say in order to work here, you're going to have to do an attestation form, give us the attestation form, because if we don't have this form, we're not letting you in. If you haven't let them in, they're not working for you, you don't pay for the time. All right, any other questions?
Yeah, the question before that, can we require a potential employee, so an applicant, I guess, to provide us with a vaccination status? And yeah, you can make being vaccinated a condition of employment. So, and again, but subject to, as Janette pointed out, either a medical or a religious accommodation. But yeah, so absolutely. After you've made the decision to hire them, you could say, well, as a condition of employment, you have to provide us with your vaccination status.
We've also gotten some questions about how all of this interacts with the Massachusetts emergency paid COVID sick leave. And just fortuitously, the Attorney General actually updated its FAQ recently on the Massachusetts paid sick leave and talks a little bit how it interplays with this. I'm not remembering off the top of my head the details, but we will address them in the follow-up Q&A. All right, are there any other unanswered questions that we have? I think not. So then, unless the panelists have any final words of wisdom that they want to share, I want to encourage everybody, feel free to reach out if you have questions. Feel free to reach out to us if you have ideas for other topics you want covered in the roundtable. So we had a different roundtable lined up, and we thought we better move on this ETS instead. But if there are other topics you want to see us covered, just let us know, because we love this opportunity to get in front of all of you and talk about these timely issues. All right, and I think then with that, all right, shall we motion to adjourn? Thanks, everybody. Have a wonderful day. Thanks to the panelists, and we look forward to hearing from folks with their reactions and getting back to you with the slide deck.